for the 5th District of the State of Florida is now in session. The Honorable Randy Wallace, Judge, presiding. All persons having business with the court, draw near, give attention, and you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. I've already been introduced. Let me introduce the other members of the panel. To my right and your left, Judge Eric Eisnagel from Seminole County. And to my left and your right, Judge Mary Jolly, who is joining us here today as a circuit judge in Volusia County.
Correct.
And so we have two cases that are on the docket. We're going to have a panel change after the first case. They're both civil cases. Before we get started, I would just ask that if you have any noise-making devices, phones, iPads, something like that that may vibrate or make any noise, I just ask that you put those on silent so that it doesn't disrupt the lawyers when they're giving their presentations. And there's 20 minutes per side for each civil case, and I'm going to assume 5 minutes of rebuttal unless you request otherwise. And so we have the first up is the NIAZI versus Department of Transportation case. And I see the lawyers are at the desk. So whenever you are ready to begin, you may, Ms. Harris. Ms. Harris, MEMS.
Good morning. My name is Elizabeth Harris, and I'm here on behalf of Dr. NIAZI. And 5 minutes for rebuttal would be perfect.
Okay.
Thank you. I believe this might be the first time this court is considering the application of the recently enacted constitutional amendment regarding agency deference. And the courts have not made a determination whether it's retroactive. As of my review yesterday, I haven't seen any cases that have determined that issue, but I would suggest here you don't need to reach that issue because the constitutional amendment came into effect on January 8th of last year. This notice of appeal was filed on January 8th. So I think that this court is faced with the law as it stood at the day that this case commenced. And in the event that the court determined that you needed to look further, I would suggest that the amendment is a substantive change because it sets forth a new standard review. It's not a question of providing some type of, did I say substantive? I think I did. Yes. I meant procedural. It's not setting forth a substantive right to the parties, but rather providing this court a standard of review in essence. So with that said, what we have here is a question of whether Dr. NIAZI can use his platform on Honeymoon Lake to land his helicopter. And the Department of Transportation has taken the statutory language in 33030 and determined that it is limited to actually landing in the water, sort of a maybe like a splashdown actually in the water, and has not looked at the language that follows the any body of water, the language that says including any structure, land, building that facilitates that private use. Now, important in this as well is the second issue that we raised in our brief on the idea of whether this land is even subject to regulation by the government. The department has taken that private.
You mean by the state?
By the state, yes, yes.
Who would regulate it?
Well, I believe that because it is non-state land, and it has been deeded by the owner itself, which is Stillwater's Homeowners Association, because that land is not federal land. It was deeded by the federal government to an individual back in the 1800s, and it is maintained in its. The use of the word private here causes some confusion. But for this purposes, in this private ownership-like situation that is separated from the state of Florida and separated from the federal government.
I mean, why is it any different than any other privately held land once the federal government transfers ownership? You don't cite any cases in your brief, and I assume that's because there's not a lot on point, but why is it any different?
You're right, there isn't any case law. That's why you don't see it by either side, by statute or case law that addresses this issue. But the important part, I think, the important part to answer that question with is that the Department of Transportation agrees that it's non-state land and agrees that with respect to the Department of Environmental Protection, there is no jurisdiction. So with that fact agreed to, if the Department of Environmental Protection doesn't have jurisdiction to come in and regulate that land, neither would the Department of Transportation.
Why does that necessarily follow?
Because it's not, I don't mean to throw it back at you that way, because it's non-state land. It's not land. It is not, because I think it's important here.
My house isn't state land.
Well, I think it is, because it's not, it's private, but it's still within the jurisdiction of the state of Florida.
I mean, doesn't that beg the question, though? I mean, that's kind of what I'm trying to get at it. You know, the federal government, why is, once the federal government transfers title to a piece of property, it's almost, you seem to be arguing that Honeymoon Lake is sovereign, almost. Has the status of another state, if you will, or a territory. Is that essentially your argument?
I think that has to be it, and I think that has to be the case, because when the federal government deeded it to an individual, kind of carved it out from the state of Florida and deeded it to an individual, it's now no longer under the sovereignty of the state of Florida.
But why? I mean, I understand your argument. I'm asking why. Well, we don't have any cases on point, at least not in the briefs. I'm just asking on what authority, just because the federal government transfers property into private hands, why is that now private property forever sovereign instead of just become like every other piece of private property out there?
Because the federal government, when we purchase our land, it's not deeded to us from the state of Florida. When the federal government did that, it carved this out, and it has to have done that because otherwise it becomes, that deed has no import, has no impact. Because then it would be as though it was just, I don't even know what to equate that to. Once that action happened by the federal government, it removed that land in some significant aspect that it became separate from the rest of the land. And so it has to be a situation, and certainly if the Department of Transportation in the state of Florida has agreed that it's non-state land, and agreed that with respect to one agency there's no jurisdiction, it does not seem congruous.
Well, maybe one agency doesn't have jurisdiction because there's no statutory authority.
And there's none for the Department of Transportation either.
Well, you have this statute relating to airports.
Well, but that's where I began with this conversation. I think it becomes then a question of private and public, but this is not private. My land, my backyard is private land. And if I were to build an airport in the back of my land, the government, because fundamentally that land is the state of Florida land at its base, and so the state of Florida could come in and regulate the airport on my backyard.
Essentially, your argument is essentially that when the federal government transfers land to a private holder, that it is no longer federal land, right? But that land doesn't then fall within the jurisdiction of the state. It essentially becomes its own sort of sovereign plat, if you will, for lack of a better way to describe it.
Right.
I understand what you're arguing. Do you have any authority, statute, case, anything?
No, I don't. Other than
Constitutional provision, anything?
No, I don't. And I think we're both in that position.
Is there anything in the deed that transferred the property that would support your argument?
I'm having a little bit of difficulty because I think that to suggest that the government could deed Florida land wouldn't make, it doesn't seem to,
This was
I guess
federal.
makes sense. I'm just going to call it what it is. It
Honeymoon
doesn't
Lake
make
was
sense to me.
federal land, right?
I spoke over you. I'm sorry. I couldn't hear you.
Well, Honeymoon Lake was federal land, correct? Long time
I'm
ago.
assuming at the time, this was the late 1800s, that it would have been, I don't know when Florida became a state. When did Florida become a state, I guess, is what
This
we
was-
probably need to look at first.
The record seems to indicate Honeymoon Lake was federal land, and the federal government deeded it, right? Give me your, and then we probably should move on to the statutory argument, but give me, because I think what you're saying is, look, if this second argument you've made, if you prevail on that, then the statute doesn't really matter, right?
Right.
Give me your best argument as to why that land that is no longer federal land, why it's not under the jurisdiction of the state. And then I have some questions about the statute.
I have two responses to you. First and foremost, the agency agreed it's non-state land. That's a fact they agreed to entering into the hearing.
And they
of the
agreed
agency.
that,
It's
when they said
non-state land.
that, did they mean that the state didn't own it, or did they mean that the state had no jurisdiction to regulate it?
Well, I think it doesn't. I think by agreeing to that, they're not agreeing that they don't have a provision to regulate it. I think that they're agreeing it's non-state land. So then the question, I think, that was presented to everyone here is whether they could come in and regulate non-state land. And I think in order to do that, they have to provide a statute. And the statute they provided is this private-public airport. And I would suggest to you that is vastly different. If we look at what Dr. NIAZI has done on non-state land, built an airport, and whether I were to build one on my property, which is state land.
Does the doctor have to pay taxes on this land? State taxes?
Well, the question that is, as I understand it, that platform is built onto the submerged land. My understanding is not the land surrounding the lake. That I don't believe is part of the deed. It's simply the lake, the
It's
submerged
the submerged
land.
land,
So
right?
it's submerged, so it's not subject to any regulatory authority under your argument.
No.
Where did you argue that below? I mean, I know Chapter 120 is very specific in what issues can be raised, going from pretrial statement all the way to the agency final order. To me, I'm hearing an implicit argument that you made this jurisdictional argument because DEP didn't have jurisdiction. So from that, we're supposed to attach that DOT does not, well, I'm talking Florida DEP. We're supposed to attach that jurisdictional argument where it wasn't addressed in the pretrial statement, in the ALJ's order, and in the final agency order directly. So I appreciate your conversation, but I'm a little stuck on whether this has even been argued below and it's preserved. The jurisdictional argument as to DOT specifically.
I would suggest to you that the ability of the Department of Transportation to prevent Dr. NIAZI or to regulate this was challenged at all levels. It's from the initial statements of disputed questions of law.
As to the actual exemption, I'm talking about the submerged land argument that you're making this morning.
And I would suggest to you that the question is presented in the pretrial, and I don't think they called it a pretrial statement.
It's a stipulation, I believe.
Right. It's presented there for resolution. The question of whether that is a dispute, whether the department had the ability to do this in the non-state land. And I don't have, but when I come back up, I'll give you the page number where you can find that at. But I would suggest to you that begins there with the question of whether that's been challenged and whether it is subject to review by the ALJ and then the agency itself.
Counsel, did you look for any cases outside the state, similar cases on the jurisdictional
sovereign land
issue you're
issue?
talking about? Yeah.
No, sir. No.
How does, going to the statute, how does, is it your contention that the helipad uses the lake?
The
Or
fact-
does it use the platform that's built above the lake?
Well, the facts show us that the pilings are submerged into the lake bed. So it is on the lake bed.
The helipad is, right? It's
Right,
the pad itself is built into the lake.
right.
But does the helicopter, the statute seems to sort of suggest that, hey, if you're using a body of water, right, and then it says that's not an airport, that's an exception. It makes exception for land and buildings that facilitate that use. The appellee argues essentially, look, I mean, using the lake as the airport means landing on the water, right? And then maybe you taxi up to a dock or something to get out of the aircraft. Why is that not a better interpretation of the statute than yours? How does your client, by landing on the helipad, how is he using the lake?
I would suggest to you that the plain meaning of the statute, when you look at it, the statute says any body of water, including, and, I went through my brief sort of, definitions of these words, but including a structure, which I would suggest here, that's probably the easiest one to hear, that facilitates. So the exception would apply to the body of water, including meaning that among or incorporated into that. Maybe that's a way but the word including is extremely important here. Any body of water, including the structure that facilitates it. And certainly the heliport would facilitate the landing.
It does more than facilitate it, right? It is the landing.
It is.
It's the only landing.
And I think if you were to take that language out, including any land, building, structure, or other contrivance that facilitates it, it's an entirely different statute. If you read any body of water used for takeoff or landing of an aircraft and ended it there, it's a totally different statute than the phrase that follows, including.
Well, again, I mean, I think that the first part of the phrase is the tough part for your client, right? By using a helipad that is built on top of a lake, and then landing on that helipad, the aircraft never touching the lake, is the lake, the body of water, used for the takeoff and landing of the aircraft?
Well, I would agree with you. If I don't have that second part, I have a more difficult.
Well, don't you agree that second, the including, is attached to the first part of the subsection?
Well, I'm not sure I understand what you're asking me, but
Well, you don't even get to the including any land, building, or structure that facilitates private use. You don't even get to that part if you're not using a body of water to take off and land.
Well, maybe this is a sophomoric response, but he's clearly using the water because he's not landing in his backyard.
Is he using it, or is his dock built on it? I mean, is that the same thing?
I'm not sure I know how to answer your question because you kind of get into a brain tease with this, but
I mean, I think you have to say yes, right?
He clearly is using the dock because he has a helicopter.
And the dock...
It's going to sink if he lands it in the water.
And the dock is kind of using the body of water, although not the water itself. It's using the land below the water. And so your argument goes, look, because the dock is using the submerged land below the water, and I think your argument would be like you can't really maybe separate the water from the land there, and then he's using the dock that's using the body of water, right? Essentially is what you're arguing.
Yes, but I think we're talking a lot without looking at the rest of the statutory language, which says including.
And Mrs. Harris, you're almost got a little more than 2 minutes left of your total time, so
So I'll
reserve.
reserve. That's okay.
Good morning. May it please the court. Mark Peoples for the Florida Department of Transportation. I will confess, before today, I didn't realize that their jurisdictional argument was some kind of conk republic. It's sovereign land.
Well, I'm not sure it's entirely clear in the brief that that's what their argument is, but I questioned if that's what they were arguing as well. But it seems like if to entertain the issue, if that issue would override the statute, right? I mean, if they made that, let's assume for a minute they made that argument. Let's assume for a minute they preserved that argument, and we got to the merits. Just go with me here.
I understand.
If they prevail on that type of argument, you lose, right?
It's tough for me to answer because I don't believe that it is preserved. I don't believe it was raised.
But don't fight the hypo, right?
I'm not fighting the hypo. What I'm saying is I'm not prepared to answer the hypo because it's not something that I had prepared to argue here today, that we were dealing with this weird sovereign land scenario. I thought what they were arguing was it's private land and we don't have jurisdiction over private land, even though the statute plainly applies. You've brought up the backyard.
In other words, you hadn't thought about or researched this
Exactly.
concept that honeymoon that somebody can do anything they want on Honeymoon Lake because it's a sort of a sovereign.
That is international waters and
Right.
all of us.
Deal.
No, not something that I think the briefs ever contemplated. So I apologize if you take what I was doing as fighting the hypo. It's just it's not a hypo that I considered. If it's something that the court is interested in, happy to provide supplemental briefing on the question. And I
Generally speaking, can you address it in terms of what the agency's regulatory powers would be? I mean, you're saying you can't even address that part.
over if it's truly federal land or international land or some kind of quasi.
Is there anything you can point to that could provide for some
The statute's quite broad.
application? Yeah.
Right? The statute's quite broad, that you have to register an airport. And an airport is any area of land or water used or intended to be used for takeoff and landing. Obviously, we're talking about within Florida. The Florida DOT can't regulate Hartsfield Airport or LAX. But if it's within our boundaries, our position is that, generally speaking, and again, I haven't researched that little curlicue.
When you agreed below that the Honeymoon Lake is not state land, what was the meaning of that?
We agreed it was private land, which I think is an important distinction. Right, and we agreed.
You didn't view that as an agreement that the state of Florida doesn't have jurisdiction over Honeymoon Lake.
Of course not. If the DOT had stipulated we didn't have jurisdiction, we wouldn't have been there.
What about the statute, though? All right, I mean, essentially, I think I understand. I think I understand both sides' argument on the statute, but in some way, right, this helipad is using the body of water. I mean, can the statute not be read that broadly?
Well, if the helipad uses the body of water, that's different from the helicopter using the body of water. The ALJ did what, in my mind, is...
Well, but the statute doesn't say the helicopter doesn't actually say the helicopter must use the body of water, right? It says any body of water used for the takeoff and landing of aircraft.
Right, and the ALJ found that the dock is not a body of water. It's in my mind, an impressively detailed example of textual plain language analysis within the recommended order. He goes so far as to define not only facilitate, but to define water. There's a good page and a half in the recommended order defining the word water, which is not defined in the statute.
I mean, I think the appellant's argument is, look, the helipad is built on the body of water, and while the aircraft itself isn't using the water itself to take off or land, it's using the helipad, which is using the body of water, and that they kind of point to this second part of the provision to say, well, the connection between the aircraft and the body of water is this helipad that is facilitating the use, right? I think that's kind of...
But they're not, but you get back to, are you using the body of water? Yes, land, structures, other appurtenances that facilitate the use of the body of water count under the statute. But if you're landing on the land, the structure, the appurtenance itself, it doesn't count under the statute. It reads, any body of water used for the takeoff and landing. If you're not landing or taking off from a body of water, and again, I refer you to the recommended order, it goes into impressive details of what exactly a body of water is.
I suppose if somebody could just build a helipad on Honeymoon Lake and there was no ability to regulate it there, then, I mean, I suppose you would take it to the extreme and say, well, what if there were, 30 helipads built on Honeymoon Lake in order to avoid the state of Florida from having any ability to regulate it? Would you, I mean, do you think that if we take the appellant's argument, if we take their interpretation of the statute, is there any sort of limit to what could happen on Honeymoon Lake as far as takeoffs and landings?
If we take their argument?
Right.
Not that I can see. No.
Is there any functional benefit to having the helipad over a body of water versus just having the helipad with the water irrelevant, having there be nothing underneath it? Was there anything in the lower court below that would establish any reason or benefit?
If I'm hearing your question, and I'm not sure that I am, is there some kind of practical reason why you'd want to build a heliport?
Right, practical, functional.
Yeah, over a body of water as opposed to just build a big structure in your backyard and land it there?
Right.
My guess is, and this wasn't developed below, but my guess is that he decided to do this to try and sneak in within the 3F exception. That you can, if you squint, if you accept their argument, that we're using a body of water, sorta, kinda, because we're embedding this dock into a body of water. But if you went out and built a big platform on pilings in your backyard and landed on that, well, there's no body of water there. So that's, my guess is that no, there's no practical benefit to doing it that way. It's just, he didn't want to register.
I have this
He wanted to land
vague
in his
recollection that somewhere in the record I read a suggestion that, and I can't remember where it was, or I think it was in this case where the appellant either considered building it on his property or tried to but couldn't get a permit from the county. Is that this case? Am I remembering the record correctly? But the county didn't have jurisdiction over the lake, so.
Judge,
Don't know.
That could
All
be.
right.
That could
It's
be.
just a vague.
Yeah.
Okay.
And if it's important, I'd be happy to look at it, but I don't recall that specifically. So in any event, I think the statute's fairly clear. The AOJ found it was fairly clear that under a textual reading, they're not using the body of water to take off and land. They're using the platform. A platform is not a body of water, and therefore the statute doesn't
Let's look
apply.
at the rest of the statute. How would, just entertain me here, how would the license and registration sort of process look if the appellee were to license and register a lake where people were flying in their seaplanes and stuff on a regular basis? If this exception wasn't there and now that's an airport, what would that look like for the appellee, considering the rest of the statute?
And that's the difficulty. That's why the exception exists. We can't inspect water. There was testimony there. That's the basic reason for the statute. That the registration requirements are there because fundamentally our job as the Department of Transportation is to ensure a safe and efficient system of transportation in the state, and therefore we have a rigorous inspection regime for these airports, public or private, but you can't inspect a lake surface. It literally changes every minute as the water cycle goes, and it's just infeasible to inspect a lake surface, and therefore it's not lake surfaces themselves are not within the inspection regime, and the legislature saw fit to carve that out explicitly, and if it wasn't there, then we'd have a problem, because for any seaplane or helicopter fitted with pontoons that wanted to land on a water, what would we do? We inspect lakes, oceans?
In other words, your duty under the statute would be sort of unclear when applied to a lake where...
It would be clear, but what on earth would we do?
Well, that would make it unclear, right?
Right.
Okay.
So, and there was certainly testimony as to that below. And one thing that, that Judge Jolly referred to was the preservation issue. What wasn't raised much with respect to the issue of the statute interpretation itself. While I think that the ALJ's exegesis of the statute was detailed and quite a good example, in order to preserve an issue for review from an appellate proceeding, from an administrative proceeding, the petitioner has to take proper exception to findings of the recommended order. And the exceptions here did not take exception to the ALJ's interpretation of 333F.
Do they have to take exception to legal conclusions or just factual conclusions?
Yes, yes, taking exception to legal conclusions. In fact, how they framed their exceptions were all within the context of the ALJ failed to consider and give appropriate weight to, and those sound like a preamble to I'm going to take issue with factual conclusions, appropriate weight, right? And then the closest that they come, though, I'll go down them. The first exception, there was only 4. It takes up 2 pages of the record. The first one was that it's impossible for Dr. NIAZI to land on a lake without a structure because his helicopter doesn't have pontoons and he'd sink. The second exception was the DEP acknowledged it had no jurisdiction over the lake. The third exception was it's actually more dangerous to land on a lake than a dock. And the fourth one was that took exception to the ALJ's conclusion that NIAZI failed to meet his burden to show that the exception didn't apply. That's a factual question. Whether you satisfy your burden of proof in administrative proceedings is a factual question. And he said, no, we actually did prove it. But again, he's taking issue with the facts. He didn't make the legal argument. The department never had the opportunity, never was given the chance to rule on how 3F should be interpreted, whether was the ALJ right or not. And therefore, that issue isn't preserved because the lower tribunal, and the lower tribunal here isn't DOA. The lower tribunal here is the Department of Transportation. The Department of Transportation was never given the opportunity to rule on whether 333F applies to this dock. And therefore, it's not preserved for appeal. I have 7 minutes left, and I'm happy to entertain any other questions, but in my mind, it's a fairly straightforward case, and I urge the court to affirm. Thank you.
Thank you.
Judge Jolly, I told you I'd give
Can you
pages.
respond to the counsel, appellee, counsel for the appellee's argument that you, do you agree that those exceptions were all factually based, and does that preclude then that you didn't specifically ask for the except on the legal conclusions? So can you address that portion of it, of his argument?
I can agree that the exceptions were, and the question of the burden of proof here becomes circular because the burden of proof is whether he fit within the statute that they have defined in the way they've defined it. So it becomes a circular argument. But my answer to your question would be reference to a case out of the first DCA that says to properly preserve for appellate review, it must be raised in the administrative proceeding. You cannot raise issues that are not properly accepted to or challenged. And I would suggest to you that this was amply challenged in the record. And I would give you 196 Southern 3rd, 1290.
Yes, my question is, I don't disagree that that's what the hearing in front of the ALJ was. Does that then, on the meaning of subsect the exception, so if it's argued at the hearing but not accepted, that still preserves it for appellate review? Is that what you're essentially telling me?
That's what I would argue. Because everyone's had the opportunity to address the issue.
Well, he's
And that's
saying the
idea
agency
for-
hasn't in its final order because it wasn't accepted to.
Well, but the agency is required to review it in its entirety, much like the trial judge would with a general master. So I would suggest to you that the situation is analogous, and that this issue was challenged below, and the argument is not, it's not something that's not been raised before. And in response to your question about the private sovereign submerged land, I would reference record 42, page 42, in that it deals with the joint stipulation, and specifically the parties agreed to the following facts: whether Honeymoon Lake is currently classified as private sovereign submerged land, and what effect that classification would have on the authority of the department and the Brevard County to regulate activity in the lake. So they agreed that was a disputed land. In the recommended order, the ALJ finds Honeymoon Lake is private, in quotations, not state body of water. The U.S. government deeded Honeymoon Lake to the original developer in 1878. The area of the lake where Dr. NIAZI's heliport is located is owned by Stillwater Homeowners Association, so it's maintained that. So I would suggest to you that that issue was raised. They agreed that was a disputed issue of fact by stipulation.
Well, I think that there's no finding it's submerged lands. That was when I was saying it was implicit. I mean, that's to what I was referring to, that what you read initially, but then what you quoted from is somewhat implicit. I'm not saying it bars your argument. I'm just saying, to me, it's implicit in terms of a specific finding that it was state submerged lands regarding the entire line of questioning from my colleague.
Perhaps, because I don't know what you make of not state.
Right.
So if
And I took up her rebuttal time if there.
Okay. We'll give you 2 minutes to wrap up, Mrs. Harris.
I just wanted to go to your scenario, Judge Eisnagel, about having, if there were 30 heliports there. If we took that and looked at the department's position on the statute, suppose that there were 30 people on that lake landing their seaplanes with docks. They can't regulate that either, because they said this is for disembarking. So imagine in your head, in your same type of scenario, that we have lengthy disembarking docks with seaplanes landing in that lake. So that argument falls apart with that respect. And we need to remember that the FAA is regulating the airspace. So the issue of too many flying in there would not become a problem, because they need to get FAA approval for the airspace. But if we use your analogy and accept their position, every person on that lake could land their seaplane with whatever unregulated dock that disembarked people from the lake. And that poses the same, their idea of safety is not present in that situation if they're not able to regulate that situation. Yeah. Thank you very much.
And we are going to make the panel change. We're not going to be gone long, so.